I also should note, for the record, inasmuch as I am a judge on the Georgia Court of Appeals, and there are restrictions concerning what I can and cannot say and what I can and cannot support, that I do have the permission of the Judicial Qualifications Commission, and the Code of Judicial Conduct authorizes both Judge Teske and I to appear at your request to testify in front of legislative and executive committees on public policy matters affecting the judiciary. So in that regard, I wanted you to be aware that I was ensuring that I was following appropriate protocol. This bill that you have in front of you is 200, I believe, and 44 pages. I won't presume to go through every bit of it, but I want to start with the premise that the council was charged this year, and we're a larger council this year. Last year, the Council on Criminal Justice Reform dealing with adult matters was only 13 members. This year it was 20. We're trying to be, and I applaud the governor for this, more inclusive. In addition to the membership on that council, which included sheriffs and lawyers and prosecuting attorneys and members of the House and Senate and members of the judiciary, we reached out. Thomas Worthy is governor's deputy executive legislative counsel, and he and I met with several stakeholders throughout this 6-month process. We were charged specifically this year, unlike last year, with really taking a look at juvenile justice reform policies and practices. I thank Commissioner Avery Niles, who is here, and the effort of the Department of Juvenile Justice in assisting the Pew Foundation on the States in ensuring that we gathered the appropriate data, analyzed the appropriate data, and then indeed that we looked at public safety outcomes and fiscal implications that to drive, if you will, the recommendations that we have made. So with that, I want to go through some of the data that drove our considerations. You've got some handouts that will reflect some of this. If any of you have any questions when I get to the specific recommendations, I can point you where in this 244-page bill the recommendations are, because as you all know, as the chairman has just suggested, you married up, if you will, the juvenile code rewrite with the juvenile justice recommendations. So all of that is in this bill. This bill is not just the Juvenile Justice, Criminal Justice Reform Council juvenile recommendations. I won't go through all of the data, but you have, do they have this document?
Yes.
All right, this document is what I'm referring to at first. And if you will take a look at it and just kind of go through it with me, I'll tell you that it starts off with the findings of the special counsel. Indeed, after we analyzed the data, I think it was important and is important for you to recognize fiscally that the Department of Juvenile Justice in FY13 was appropriated approximately $300 million for their operations. 2/3 of that amount goes to operating out-of-home facilities used to house youth in this state that are adjudicated delinquent or otherwise. So it's a significant amount of money being spent on housing youth in this state, and I think you need to know that number. In addition, you probably ought to know what kind of return on investment you're getting and who are in these facilities. First, let me tell you that the residential facilities in this state cost approximately, that is the YDCs, youth development campuses, and regional youth development campuses, cost roughly $90,000 per bed per year. That is a significant amount of money. Compares, for example, as the Chief Justice mentioned in her speech just last week, to approximately $19,000 a year to house an adult in Georgia's prison system. And there are a myriad of reasons why that number is higher that I won't get into, but nonetheless, those are appropriate numbers after our audit and review of their data. Despite the huge expenditure there, and actually before I get to that, I want to give you the numbers. We have 7 youth development campuses in the state, and those costs are actually $91,126 per bed per year. We have 22 regional youth development campuses, if you'll think of those as local jails for youth. $88,155 per bed per year to house a youth in those facilities. And we also have group homes, which are considered out-of-home, non-secure residential placements, and those group homes are expensive as well and can exceed $50,000 per bed per year. Taking that into consideration with what we spend, and you as taxpayers and Georgia's taxpayers spend roughly $200 million on Georgia's Department of Juvenile Justice, you ought to know who's in those facilities. And I think it's important, if you'll look at this sheet, which has some data on it that is important, and if you'll look at the middle sheet, part of that, you'll see that of that out-of-home population in 2011, we had 1,917 youth housed in one of those 3 facilities, a YDC or a YDC or a group home. Of those 1,917 youth, 24% of those were misdemeanor or status offenses. Status offense being an offense that is not necessarily would not be against the law if you committed it, but is against the law by virtue of the status of this youth. For example, truancy, running away, drinking underage, and that sort of thing. Of those 1,917, 40% were categorized as low risk. If you look further down on that list, the YDC population has roughly in 2011 had 619 offenders. Of course, those are felons predominantly, and that's why only 1% of those were misdemeanor or status offenders. But nonetheless, 39% of those were categorized by a risk assessment instrument as low-risk youth. So that's who's in those facilities. The top slides show you the cost. And if you look, most importantly, to the top right slide, and you'll see what kind of return on investment the citizens of this state have been receiving based on the appropriations to the Department of Juvenile Justice. Of all the youth then out of home that are adjudicated in this state, not just out of home, but all youth in this state within 3 years, 53% have been adjudicated of another offense. So it's a 53% recidivism rate of all youth across the board. Those that come out of YDCs, the number is 65%. And quite frankly, we believe, and I think you will believe, that return on investment is not satisfactory, and that maybe there's a better way to build the mousetrap, if you will. And so we were tasked with the responsibility of taking that data, determining whether that data drove any other considerations and drove some recommendations. We also found that there were limited or no community-based options in many parts of this state, and that's obviously driving some of these recidivism rates. We also know that if these recommendations, 15, that we have recommended in the juvenile justice arena are implemented and codified, that you will save approximately $85 million a year through 2018. Again, I mentioned at the onset that the cost savings through adult criminal justice reform were approximately $264 million last year. And we're already seeing, just so you know if you get asked, we are already seeing some realized savings and real results and diminished jail backlogs through your efforts in 1176 last year. It was just put in place and effective in July. But we're already seeing some, Brian Owens, the commissioner, has already testified that he's already seeing some very significant cost savings. So we're well on our way, I think, to making sure that we realize those cost savings. The cost savings here are going to be roughly $85 million. I can go into detail into how we get to that number if you'd like, but I'd prefer to just kind of try to go through the recommendations very briefly if I can. So if you will turn to the second page of this document, understand that the bill is again very lengthy. Everything that the council recommended in the nature of juvenile justice reform is not in this bill. Some of those items we've determined through Commissioner Niles and others can more appropriately be handled through the budgetary process or through a regulatory process. And so everything we've recommended is being handled in one way or another, but it's not all necessarily in this bill. I think of the 15 recommendations, there are only 8 recommendations probably that we've made that are required to need legislative action. One of the things that we have recommended and that is in this bill is that we create a 2-class system within the Designated Felony Act. If any of you are familiar with the Designated Felony Act, you'll know that it passed in 1981, 32 years ago. At that time, there were 11 offenses, and they were serious offenses, as you might imagine, the most serious offenses that a juvenile could commit. That act, however, has morphed over the last 32 years, such that there are now 30 offenses within the Designated Felony Act, running the gamut from murder to smash and grab burglary. That's not necessarily a bad thing, but what the council thought might need revision and revisiting was that there is one disposition available to a judge for all classes of designated felons. Judge Teske, when he handles those cases, is limited to one class of disposition. That is one sentence available. It's not a mandatory sentence. There's a range of sentences, but it's the same range for the least severe of those offenses to the most severe of those offenses. We didn't think that was appropriate, and so we've asked that you consider codifying legislation that would create a 2-class system within the Designated Felony Act and give sentencing judges like Judge Teske and other juvenile judges throughout this state some discretion to handle sentencing those offenders of less serious consequence to no more than 18 months in secure confinement, as opposed to those that are the more severe, they remain up to 60 months of confinement. So we're not suggesting that you do anything different with that. Next, several states have implemented strategies to not send status and misdemeanor offenders to the most costly of the secure facilities in your state, or in their state. We've looked at the data, and we believe that prohibiting status offenders and certain misdemeanors from residential commitment is an appropriate mechanism to return to Georgia's taxpayers a better public safety and fiscal investment return. Virginia, Texas, Florida, Alabama have all implemented similar policies as to what you have in this bill. And in short, we're asking that you codify legislation that would prohibit a juvenile judge from sending a misdemeanor or status offender to a secure facility unless certain criteria is found. We still want to give judges that opportunity because every case ought to be judged on its own merit, and no two cases are alike. Next, and very importantly, and in recognition of the fact that there are limited, in some instances, no community-based options for the youth that are arrested in your community, we have developed and will be hopefully developing a fiscal incentive grant program that would allow communities to apply through an RFP that is being drafted as we speak in anticipation of this, and allow them to in essence, fiscally incentivize them to not send their youth to an expensive, secure facility, but rather treat them in the community. And we would allow them to treat them in the community by allowing them to build evidence-based practices that have been proven to reduce recidivism, practices that have been proven nationally as promising, or proven practices that we know produce a better public safety outcome. And it would be paid for, of course, through this fiscal incentive grant program. The governor, fortunately, has included $5 million in his proposed budget for next year, I guess FY14. Right. And you will all have an opportunity, I guess, at the end of the session to vote on that. And it is in that budget, and we applaud the governor for his financial investment in this fiscal incentive grant program. Just so you know, there's also some money in the governor's Office of Children and Families, $1 million that would be married up with that $5 million if that budget passes and this bill passes. And so ultimately there would be $6 million available to the communities in this state through a grant program to build community-based programming. Much like accountability courts, but not necessarily an accountability court. It could be a group counseling program. It could be an anger management program, all built on proven practices that we know reduce recidivism. So that is a very significant, we think, piece of House Bill 242. In addition, we have required, and will require in this bill if you pass it, we've recommended that the Department of Juvenile Justice ensure that resources are focused on programs proven to reduce recidivism, and to that end, that all of the programs that are implemented in the state be evidence-based or promising practices programs. That is, programs that are built around a philosophy and a curriculum that has been proven to reduce recidivism. I will tell you, as a former Superior Court judge and as a drug court judge, that some of this is quite counterintuitive. Many of you are parents. Many of you understand the effect of a hammer and or stick and carrot approach, if you will. Sometimes you have to have a tough love. Sometimes you have to be a little more lenient. I thought, when I became a Superior Court judge, that I could preach offenders straight, that I could threaten them enough with prison that they would not want to go and that they would therefore quit using cocaine or quit their felony conduct. I will tell you that that was a flawed philosophy. It does not work. It would work for you and it would work for me, but it does not work for somebody that has a significant mental health or substance abuse problem. And so, one of the things we want to really push as a council was that there are evidence-based practices out there. There are programs that we know do work. Many of you, I think, like me, through the years have probably seen TV programs, these Scared Straight programs that take youth into prisons, and it scared me, and I wasn't there. I was watching TV. But it doesn't work for these youth. We know that because we follow the recidivism rates of the youth that are involved in those, and we know that those sorts of things simply don't work.
I need to interrupt you for a moment, just because I've got to leave to go. Business goes on here, even though we have committees. I've got a bill that's very important to my constituents, and I need to go present that. But I'll be back as quick as I can get that done. I'm going to turn it over to my friend, Mr. Weldon, to chair while I'm absent. Thank you.
All right. So one of the recommendations then would be that we provide that evidence-based and promising practices must be used. You heard me earlier say that many of the youth that are in our youth detention centers and our entire population are low-risk youth, and you might wonder how we determined if they were low-risk youth. We use risk assessment instruments, and it is a recommendation of the council that these instruments be validated, that is, that they be proven to be what they purport to be, and that is appropriate instruments to determine the likelihood of recidivism of the youth against whom these instruments are applied. It is important that these risk instruments be validated, and we've recommended and is in this bill a language that would require that risk assessment instruments be used to determine risk for recidivism, and that the decision makers, namely the judges and juvenile justice, have this information before they make detention facility or detention decisions. Next, you're all aware that in the adult arena, any of you that practice criminal law understand that there are several types of probation in the adult arena: active probation and inactive probation, sometimes called administrative probation. We have purported that there be an administrative caseload process in the juvenile justice arena, and that is that where appropriate and where permitted by a judge, most importantly, that a youth that is placed on probation could be placed on administrative probation with less rigorous obligations. Of course, that would free up caseworkers to focus on youth to whom they can have the greatest impact, we think. Next, one of the problems, quite frankly, that the council had, and I think DJJ has, is that we don't really have the data that we need to make a lot of the decisions in this state. I think we have good data, and probably comparatively, we have better data than most states. But there was still some data that was missing that we really feel like there ought to be a uniform methodology of collecting data. There ought to be a uniform system for reporting and tracking that data. And so one of our recommendations is that the bill would mandate uniform data collection and tracking, and also require the use of performance-based contracting. And that is, if you built a community-based program and you contracted services, counseling services, that counseling services contract would have to be a performance-based contract that was going to be audited, that was going to have to be proven to reduce recidivism, or they would not be entitled to compensation or further contracting renewals. In addition, we had fortunately reached out to the sheriffs, and we had Sheriff Berry from Oconee County as a very active and supporter and member of the Council for Criminal Justice Reform. And his recommendation, there's also a recommendation in here that the requiring agency that's dealing with the youth, the arrested youth, be responsible for transporting that youth to a detention facility if a detention decision has been made. And so that recommendation is in here as well. Now, I've gone through fairly quickly those recommendations. Those are really the premise of our recommendations, not focused solely on cost or fiscal considerations, although that was important. I think the council took very seriously their obligation to not do anything that would harm public safety. Public safety was the most paramount concern of the members of the council, as it was last year with adult reform. And it was a driver, quite frankly, of the considerations that the council had this year. But those are, in a nutshell, an outline, if you will, of the council recommendations that are in this bill. I'm happy to answer any questions. I do have Jason Newman from the Pew Center on the States that helped gather the data. And I want you to understand that the data that we based our decisions on was your data, was Georgia's data. It was data that was derived from the Department of Juvenile Justice and courts in this state. And that's the information we use. So, Mr. Chairman, that's my presentation.
Thank you, Judge Boggs. We have a question. Recognize Project Bruce for posing questions.
You beat me up when you came in the room here.
I'll try to make it easy on you, Mr. Representative.
I do have a question.
Sure.
In the normal court system, there's a pretrial intervention program. I'm sure you've heard of it. I know things are a little different in the juvenile courts in terms of trials and things like that, but is there something that's in here, and I haven't read the whole thing, that can address something similar, that's before the child is actually incarcerated or jailed or whatever the term is?
Sure.
Is there something that can be done similar to a pretrial intervention kind of thing at that level?
Oh, Judge Teske.
Yes, sir. In fact, the question you're asking is we have mechanisms in the current code, and in what you have in front of you, it has not changed. However, what you do have in front of you is going to promote further what is currently in the code. Let me briefly just describe. For example, 151110 in the code right now is titled Community-Based Risk Reduction Programs. That is carried over into this current proposed legislation. What it does is authorizes juvenile judges in their county to develop intervention programs. They are allowed to bring stakeholders together to develop written protocols for the purpose of addressing delinquency, deprivation, and unruliness, which will now switch over, if y'all pass this, to delinquency and chins, and because now it's all going in the unruly into the chins. But it goes one step further. It has language for intervention, okay, to develop community programs to prevent delinquency, to prevent the unruliness. Now, we also have in there informal adjustments. Courts are already authorized to divert cases away from the formal process. That's where the whole assessment process is so important, to help local courts identify what are the right kids that need to be diverted away, because we know the lower the risk the kids, the more we let them go into the system, the worse they will become. That is a fact. We know that now, okay? But what this legislation here will do to enhance what's already in the code is money. Money. Because the problem is, there's only so much you can do in prevention if you don't have the resources to do it. And what we're talking about now in terms of reinvesting this money, the incentivized program that the governor is proposing, is to do what judges across this state have been complaining in all my 14 years, including me, and that is give me more money. The only way you're going to do it is to raise taxes or that's it, raise taxes. That's not an option. But we don't even have to consider that when we already have resources within our own budget if we just do things differently.
One follow-up, if I could. As I understood what you were saying, some of these programs would not have to be run by the government itself or the courts themselves. They could contract that out to third-party individuals who demonstrate the ability to do the work. Is that correct?
It would be based on performance-based contracting obligations, but otherwise, yes, you could build. I don't think it would be appropriate for this. The council didn't think it was appropriate to tie the hands of every community and make you build the same thing everywhere.
Okay.
The resources are different in Clayton County than they are in South Georgia, and quite frankly, the communities ought to have the liberty and luxury of building a program that works within the confines of the resources that they have. And so the recommendation we've made, we believe, fits that.
Thank you.
And also, thank you, Mr. Representative. And I was remiss in earlier, David McDade is here as well. David McDade is a district attorney in Douglas County, and he also served on our council along with Danny Porter, the DA in Gwinnett County. And I want to thank him personally for his assistance, and Mr. Chairman, in helping the council arrive at these recommendations. And also we produced a report. It's much shorter than the 244-page bill. It's only 33 pages, and if any of you would like a copy of this report, I can get you a copy. But this report outlines, in a very brief portion, the impetus for each of the recommendations and outlines the specifics of the recommendations. It also contains some data that was kind of driving those considerations. So if you want a copy of this report, is it in your packet? Yes. Wonderful. You have that report.
Thank you, Judge. We have another question for you. Recognize Representative LaDawn Jones for the purpose of asking a question.
Thank you, Chair. My background is a former prosecutor and now criminal defense. So I have seen in the courts a lot of, you had to leave one to do the other. But one of the biggest complaints that we saw from the community were the burglaries committed by juveniles. And so I'm taking a look at the special report and looking at the designated felony breakdown in the back, and just wanted to know the council's kind of thoughts on the burglary. I see that the smash and grab burglaries are considered a Class B. Smash and grabs are typically commercial properties, whereas the ones in people's homes were the ones that we heard the most complaints and concerns about, and just how this the act may have addressed that.
Yes, in fact, we had significant and extensive discussion when we were breaking down Class A and Class B, and that issue, Representative, came up. First of all, you're correct. Burglaries, not only in Georgia, but also across the country, we've experienced a significant increase. It used to be theft by taking motor vehicles and theft by receiving. Interesting, they've gone down, burglaries gone up. I'm not going to spend the time explaining why. Suffice it to say you're correct. However, let me share this with you. Please bear in mind that what we haven't mentioned is that we already have a very tough law on burglaries in the juvenile code. If you commit so many burglaries, I have no choice. I have to send you to Superior Court. You have to go to adult court. Okay, if you are 15 years of age and you have you've been adjudicated on 3 prior burglaries, goodbye. So let's just keep that in mind. Okay, that was part of our discussion. It's already in our current legislation. I mean, it's already in our current law. It's been transferred over. Smash and grab. In fact, it was very interesting because it was Danny Porter, distinguished DA, among the other distinguished DA.
Good
Good like that. Okay. Anyway, here's the thing. Think about smash and grab. And Mr. Porter made a very good point. What I consider residential burglaries to be a violent crime. We have to be very careful. We had this type of discussion. Just because it may be classified in the criminal code as property offense doesn't necessarily mean it's strictly property. It depends on what you're doing with the property. If you put a teenager, unlicensed, in a vehicle who steals the car, that's dangerous. And we know that. You have kids breaking into homes and they think, and you know what? It takes 2 or more. Kids like, misery likes company, especially among juveniles, okay? One in the front, one in the back, there's a lookout, okay? But they think no one's at home, and how many times have we read in the newspaper somebody's been at home and somebody gets hurt, and even the juvenile gets shot and killed. It's scary. It is violent. It is dangerous, okay? So we understand that. But smash and grab? What is smash and grab? Running a vehicle through a convenience store when it's closed, putting a chain around an ATM machine and running off, okay? And the other thing, too, that Mr. Porter pointed out, smash and grab, the legislation came in when all of a sudden that was the thing to do, smash and grab. But even Mr. Porter pointed out, you know, we're just not seeing as many smash and grabs like we used to. Oh, there have. I think there was one that happened not too long ago, okay? But they're not happening as much. But what we did, if you look at Class A and Class B, notice what we did. Anything that involves a physical injury, anything that involves injury, okay, is Class A. Notice we separated aggravated assaults. Aggravated assault with injury, Class A. It's serious. It hurts somebody. Notice Class B. Why it's in Class B? Because they're not attacking a person. Okay? We are not seeing injury out of a person in that one. And so I want to make a point to distinguish. That's how we did Class A and B. Injury, non-injury.
Yeah, Representative, also remember that the burglar's never been a designated felony act. It's not, for some reason, notwithstanding the morphing of this bill, of the designated felony act over 32 years, it was never added. Smash and grab burglary was, but the concept of regular burglary, as you have dealt with, is not there unless it's the 4th offense. So we had to address it, but we had to address it in a different way other than stratifying it between an A and B class felony.
I think the community would be in strong support if you did, but I'm sure you all did thorough thoughts on it. My last follow-up question, point system. I didn't know if that was codified or not. Was that addressed as part of this bill?
The driving point system?
No, the points, the
detention?
juvenile
Oh, yeah.
detention point system, yes.
Yes, that is included in here, but keep in mind that the detention assessment instrument is a guideline, okay? And that the juvenile judges will be allowed to override the detention assessment instrument by court policy. So for example, if you have community A is experiencing these types of crimes that are serious, okay, where county B is not, county A should have the discretion, that judge should have the discretion to say, you know what, for right now, I'm going to do an automatic override. I don't care what the score comes out to be, and I can justify it because this is the data that I have. So, you know, remember the DAI may come up with a number, but the DAI also has a provision for aggravating and mitigating circumstances, so that the intake officer can look at it, or the judge, and say, you know, even though it scores this, there's some aggravating factors based upon the questions we've asked the family and the child, okay? Or there may be mitigating factors, okay, that may take a high score and bring it down. So it cuts both ways.
Thank you.
Thank you, ma'am. I have another question for you. I'd like to recognize Judge Johnny Caldwell for the purpose of posing a question.
Judge and I had this conversation with the representatives who came to see me earlier today, and I appreciate them coming to go over it with me. I've discussed with two of my juvenile judges, and they are concerned, and I see in your report, prohibiting status offenders and certain misdemeanors from residential confinement. That I can understand. Their concern was repeat misdemeanors, and I understand you get to a 5 level, but repeat status offenders, though, that, well, there's an example I used when y'all were talking with me, the young girl or young boy that continues to run away over and over and over and over, and nothing but confinement, or as the judge said to me, how am I going to enforce my orders with these type of people who are doing it? What would this bill or your recommendation do? Would they still have the option to confine if they thought it was necessary?
The short answer, Judge, is yes. Yes, and I can point to the language. I'm trying to find it here. Let me get it. Yeah, if you look on page 161, or just give you the reference, it's on page 161, beginning with line 5585. If you would read that section and draw that to their attention, those are the provisions that allow for a misdemeanor, typically not to be sent to a secure facility, but authorize it if judge finds it otherwise.
What about the status offender, though, the runaway, the truancy, whatever, you know? What can they do with them to?
Status offender.
Yes. What the proposed legislation mirrors the core protection in the Juvenile Justice Delinquency Prevention Act, which does authorize a juvenile judge to detain a child for up to 24 hours. However, the judge may detain beyond that, provided that there is a report that's made, the child is interviewed, to determine how the child's psyche is there and whether it's really needed for that child to remain there. Let me point something out. The reason why this is important is because we receive federal money from the Juvenile Justice Delinquency Prevention Act, which is administered by the Governor's Office for Children and Families. We are audited every year by that federal agency. The one core protection, there's 4 of them, that we're the closest at risk of losing our federal money is this one, the locking up of status offenders. And so, while we realize, and as a juvenile judge, I agree with your juvenile judges what the problem is. In fact, I will tell you, Representative, I wrote an article a couple of years ago, published in a journal, about this very issue, and that this is the toughest thing that judges have to deal with, because these are low-risk kids as far as committing a crime, because they haven't committed, but they're the highest needs. And they tend to do things that are going to hurt themselves. So a judge is caught between, am I going to be paternalistic, so to speak, and lock the kid up to protect the kid from himself, or do I put the kid into a detention facility where we're working that only reserved for the highest, the most dangerous kids, and make them worse?
My only question, what can they do with that under this proposal?
Well, that's what, and you know, and that's the thing.
And particularly in the rural, and Judge, you certainly know from where you come from, like with me.
Yeah,
We don't have all these facilities and psychologists to operate with, to go do the psyche for 24 hours. We just don't have it.
Couldn't agree more. The recommendation was that status offenders be prohibited from being placed in secure facilities post-adjudication, period. And that's on line 4333 of page 125. So I misspoke earlier when I said the judge could do that. That's for misdemeanors, not for status offenders.
Right.
Status offenders, what is in the bill now is that they are prohibited post-adjudication from placing a status offender, regardless of the number of status offenses that offender has, in a secure facility post-adjudication. There are plenty of available remedies pre-adjudication, but there won't be any post-adjudication. But the thought that through this fiscal incentive grant program, that communities would, like rural communities in particular, because believe me, I can understand the challenges of lack of community resources in rural Georgia as well as anyone, having started a drug court from scratch with really no resources, and I realize how difficult that is. The idea, though, would be that if these local communities applied for and were receiving some of this grant money, that would offset some of the local burden if there was any, and that they would have to treat those offenders in the community. Now, while that's expensive, I think it's also important to note that that's more effective. And that's the whole idea, is that treating them in the local community with evidence-based programs is more effective. The challenge, of course, is how can you treat them in those programs if you don't have the program?
Don't have them. And then the process of getting those set up, and what do you do in the interim while they'll be, if you're fortunate enough to have one set up. And that was their concern when I discussed this with them.
It's a legitimate concern, but I don't think it ought to be overriding, and in light of the real effect that the prohibition against status offenders would have on the overall picture of what we're recommending. But I recognize the concern and appreciate the question. Thank you.
And it's 15, if I may, is 1511.4.12, where a child alleged to be a child in need of services, which would be a status offender, may be held in secure residential facility or non-secure residential until a continued custody hearing is held. You know, yeah, and you know, so it you know, and one other thing is that what we're trying to do is get, especially to these rural areas, the monies that are so needed to do some of these things that your judges cannot do now. That hopefully in the future, that we've heard from other states who have done this type of reinvestment you know, planning, is even develop local residential centers within their county, which is really good because it keeps them near their family instead of miles away.
And while there's been no commitment from the executive branch or otherwise, I think it's fair to assume that if these things work, I would hope that we could convince that they be ongoing, and that future Appropriations Act include refunding the fiscal incentive grant program. But thank you, Mr. Representative, for your question.
Any further questions for these witnesses? Thank you very much.
Judge, Chairman,
Thank you, sir.